My name is Jay Edwards here with Mo DeWitt. Just remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt-Law, or you can interact with the show by sending an email. You can send it right now to ask@dewittlaw.com. That's ask@dewittlaw.com. Or you can also call and leave a voicemail too, if that's easier, at 407-53-MOSES. That's 407-53-MOSES. Every Sunday morning right here at 10 a.m., you'll learn how Florida's legal issues affect you with your host, Mo DeWitt of the DeWitt Law Firm. Mo will answer your questions and discuss the latest legal issues affecting the citizens of Central Florida. Hello, Mo. Happy Sunday.
Happy Sunday to you, Jay.
I know last week we were talking about, the shady people out there doing bad things, trying to take advantage of people during Hurricane Ian. And I saw a guy they made him an example out of him already in the news earlier in the week. Guy had zero license, no nothing, walking around with some sort of ID he made up, clipped on his shirt, walking around with a clipboard and taking deposits from people to fix their roof. And he's not a roofing contractor at all.
I mean, unfortunately, we see it every time there's a storm, whether it's a hailstorm or a hurricane or whatever it is, people come around with laminated badges and a clipboard and they look official. And, unfortunately, some people fall for it because, you're desperate at that point. You're trying to get help. A lot of times you need it quickly before there's more damage that's occurred to the roof or water damage or whatever it may be. And so it's tough. I get it. But yeah, there's these unscrupulous folks who every time they come around, but I'm glad they're cracking down on it. At least it seems like they've kind of they have become more aware of it and they're really being more proactive in going after them.
Don't you just wonder if these people put in the same amount of effort and energy into scamming people? They could actually have legit good jobs, probably.
Every time I watch the show American Greed, I don't know if you've ever seen that show, but I always say, like half these people, if not more, had they just taken that amount of energy and put it into almost any legitimate business, they would have done well. Instead, they just have a criminal enterprise of some kind.
I don't know. Maybe it's more exciting for them. I don't know, but
I think there probably is some sort of psychological element to that there. But
it's another show for another day.
Exactly.
All right. Well, we've got a stack of questions, people wanting some advice from you here. And so let's go ahead and, again, you can email yours to ask@dewittlaw.com. Let's start off with this from Robert. Mo, hope you're having a great day. Quick question for you about what is Florida's total loss threshold? Is it 80% or 66? I will start off by saying, Mo, I have no clue what Robert's talking about. He says, I keep reading everywhere that it's 80. And so I've also heard 66. I just want to verify. So what exactly is he asking?
So what he's asking is basically, if you get in a car accident and your car is damaged, at what percentage do they total out the vehicle? What percentage of the value? So if the repairs typically exceed 80% of the value of the vehicle, then they're going to total it. They're going to declare it a total loss. And so a lot of people, we get issues with that because, hey, you have a car that runs great. You've had it for 10 years. And yeah, it's not worth a whole lot on the resale market, but it's worth a lot to you. So then if you get in an accident that's, no fault of your own, and, maybe the car is only worth $2,000 or something, but if they total it out, you no longer have a vehicle and you have to go spend a bunch of money on a new vehicle. So, that's a difficult situation people get into. Now, there is an option sometimes where even if the insurance company totals out the vehicle, if it reaches that 80% threshold, where you can basically say, I don't want you to total it out. I want to basically keep the car. And then you have to go apply for a salvage title. And so now your car's really worth nothing because it's a salvaged vehicle and you have to take it to an auto body shop and get it basically where they certify it's now roadworthy to go back on the road. So there is a process, and then you have to apply to the DMV to get a salvage title. But there are some certain circumstances, and we've had people do it before where they really want to keep the vehicle. So that is an option if that's the case here. But yeah, I mean, a lot of times especially with older, good vehicles, and we saw kind of what the car market did during COVID. Certainly, I don't know if it's
find them.
Yeah, I don't know if it's still like that or not. I haven't shot for a car in a while. But cars became very expensive, and so it became tough. Where hey, you're in a car accident, someone smashes up your car due to no fault of your own. Now it's getting totaled out, and you had a good daily driver that you have to replace. So it can be tough. So that's what he's asking essentially. Is kind of what's the percentage there as far as when the insurance company looks at how much is this going to cost to repair versus is it worth just totaling out the entire vehicle?
Paying you off for it. So now I know what a salvage title is, because when we were looking for a car, I saw people selling them with salvage title or whatever they called it. I'm like, what does that even mean? Now I know it's something that's been a total loss and they had to apply for that.
Exactly. So it was probably in an accident or something like that, and somebody took it and said, hey, we can fix this up and get it roadworthy, and then they apply for a salvage title and you get it back on the road.
Can I tell you, I took some advice that you gave months ago about, like car dash cams and things like that. If you happen to have them, I had somebody, unfortunately, sideswipe my son in my car, and we do have a dash cam on it. And the lady immediately got out when the police officer showed up and said, he came over and hit me. And so my son walked over with the dash cam and showed it and played it for the police officer. He just smiled, walked back to his car, wrote up the report, assigned, I guess, fault or whatever. Basically, he put what happened, what he witnessed happen on the dash cam video. And there's zero issues about who was at fault for it at all.
I mean, it's unbelievably the modern technology, more cameras like that make those types of issues a lot easier, because unfortunately you get some unscrupulous people out there, or maybe they just get scared or whatever happens. But especially around here, a lot of times they just drive off completely.
Right.
So if you have a dash cam, at least you can hopefully get their tag number. And but with more technology, there's more cameras around, even if you don't have a dash cam, where we've had cases before where it was a hit and run, guy got rear-ended, and, it's always, you're starting to get out of the vehicle to exchange paperwork and get about like halfway from your vehicle, and the other guy takes off.
And he's gone.
And then it's hard to get the license plate number that way too, because you're out of your vehicle.
And they probably know that, you know?
But in this case, anyways, the guy was on a toll road. So we just went to the toll camera down, the next toll booth camera there, and just watched for the vehicle. He knew what kind of vehicle it was, and we knew approximately what time it was. And we got his license tag number, made a claim against his insurance company, and got him.
Gotcha.
But, without those types of cameras, it becomes very difficult. But yeah, there's a lot of times, you get into this, I'll say he said, she said, but obviously it could be he said, or she said, she said, types situations with car accidents, especially T-bones. Rear ending is a little more clear cut, but when you have a question of lights or who had the right of way or things like that, it does become a little more difficult to make those determinations. But one thing you should always do, and I know nobody ever wants to do it because it's a pain, but if you're ever in an accident, you really always want to call the police and get a police report. Now, sometimes if they're super busy, they won't come out.
Right.
But a lot of times they will come out. It just takes a very long time. It can take, I've seen it take 4, 5, 6 hours sometimes. But here's why you want to do that, is because exactly what you said. So after an accident, when you call your insurance company and make a claim, what the first thing they're going to have to do is determine who's at fault. So they're going to call, even if you just exchanged information with the other side, they're going to call the other side's insurance company, and both insurance companies are going to do their own investigation and try to determine who's at fault. Now, here's what happens a lot when you don't have a police report. So if you have a police report, the insurance company is going to get the police report. They're going to see who's at fault. They might double check it, but basically they're going to go with the police report.
Sure.
If you don't have a police report, both insurance companies have to contact their insured. And 9 out of 10 times, if you don't have a police report, the person who's at fault just doesn't answer the phone for the insurance company. So now you're waiting to get your car fixed until they make a determination who's at fault. And I've seen it go on for months before, where the person's just dodging their own insurance company, and they won't determine fault until they speak to their insured. So, it can really delay things and delay getting your vehicle fixed. One thing I recommend too, which we've talked about before, is, add rental car insurance to your car insurance policy. If you don't have it, it's pretty cheap. But that way, if you do get into a situation where it's going to take a while to get your vehicle fixed, you at least have a rental car for that period of time, and you're not, having to Uber around or something like that. That's going to cost you a bunch of money.
Mo, can I get a ride?
Yeah. I've also seen, for some reason, the electric vehicles like Tesla take a really long time to get fixed. At least they were about a year ago. So that's a good thing to add. But yeah, if you don't get a police report, ultimately it could take a lot longer to get your vehicle fixed, because it's going to take longer for the insurance company to determine who's at fault. So while it's a pain to wait, those 4 hours for Florida Highway Patrol to come out and, do a police report and do their investigation, those 4 hours may save you days or sometimes even months on the back end.
In the long run, yeah.
Yeah, trying to get your vehicle fixed.
Kind of circling back to what you said a minute ago about, if you get rear-ended or whatever, it's a little bit more clear cut. What happens if, like, say I'm driving and somebody just drills me from behind, and now that pushes me into the, that sweet $100,000 Benz or something that's right in front of me, and now that causes me to hit them, even though it was nothing, I had nothing to do with this crash at all. Does that fall on me?
So usually no. So I've done some videos on this actually. So and I'll try to explain it on radio the best we can without the visual aids
Right.
here. But if you're the first car in that line of 3 cars, right? So there's a 3-car pileup. You have vehicle 1 in front, vehicle 2 kind of in the middle, and then vehicle 3. So for vehicle 1, the determination is going to be, did they feel 1 impact or 2? Because if they felt 2, that means that vehicle 2 smashed into them, and then vehicle 3 hit them from behind. So both parties would be at fault under that situation because there's 2 impacts. Now, in the situation you described, vehicle 1, the car kind of in the front of the 3-car line, would only feel 1 impact, right? Because the third vehicle hit you, which pushed you into the first vehicle in line.
Right.
So that person would only feel 1 impact, which means vehicle 3, the person on the caboose of the train, so to speak, is at fault for the entire accident.
Ooh.
So that's where, these details become very important. And, after an accident, a lot of times the insurance company will ask you these questions and you're not even thinking. You're just like, I don't know. It all happened so fast. I don't really know what happened. But answering that one question, was there 1 impact or 2, can make a completely different determination as to who's at fault for that accident.
And they know those questions they're asking.
Right. So, I mean, and a lot of times too, people, they're trying to be helpful and you're guessing, right? So that's one thing I always tell clients is, if you don't know the answer to the question, just say, I don't know. If you really don't remember, just say, I don't remember. There's nothing wrong with that. They're trying to find out what happened here. They don't want you to guess at what happened here. And so sometimes you just may not know. But that's, just something to kind of keep in mind is, whenever someone kind of starts asking a bunch of questions, especially right out of an accident, if you were injured, you might be dazed, you might be out of it, you may not really know what's going on. Just take a few minutes and make sure you're understanding the question and actually know the answer. And if you don't know the answer, just tell them, I don't know, I don't remember, or just say, hey, I don't even want to talk to you right now. There's too much going on. I need to get to the hospital first before I start giving you a statement and getting checked out. You may have a concussion. Who knows what's going on? But yeah, so it just depends how many impacts there were. But yeah, if the caboose pushed everybody in together, then they're at fault.
Okay. This has really nothing to do with any of that, but it's just a question that I want to know that just came around to this. Okay, so when you do get into some sort of accident, insurance company calls you to let you know that they're going to record everything, your conversation, so that they've got it. If you're doing that and all of a sudden you want to say something like, hey, this is off the record, whatever the case may be, does that hold up at all? Or does it really mean anything?
Well, so typically after an accident, the insurance company is going to call you and they're going to want you to give a recorded statement. So if it's the insurance company for the at-fault party, or not your insurance company, let's just say that. If it's any other insurance company that's not yours, and remember, you and the at-fault party can have the same insurance company. You could both have Geico or Progressive or State Farm. So you want to ask the person, who are you representing here? Because they have to kind of put up a wall if they represent both parties. So you want to know who they're representing there. So if they're not your insurance company, I typically recommend don't speak to them without an attorney present. There's no reason to speak to them. Now, if it's your own insurance company, you can give them a recorded statement. I recommend having an attorney present if you're going to do it. But typically you have a contract with that insurance company that requires you to cooperate with the investigation. And one of the elements to that is giving a recorded statement. Now, during that recording, they're literally recording the call. They tell you that, and they're recording everything you say, and they're going to ask you questions. Now, to your question, if it's quote unquote off the record, they may turn the recording off, and if they have to be honest about that.
Right.
But it doesn't mean that they're not going to note their file of what you said.
Okay.
At the end of the day, they work for the insurance company.
So they can still kind of use that if they need to.
Yeah, I mean, they're I always say they're not your friend. They're there to do their job.
Yes.
You're there to try to get fair compensation for whatever happened to you. So you just want to protect yourself, make sure you're informed going through the process. But yeah, if they say it's off the record, it might not be recorded, but it's probably still going into your file.
Somebody's writing something down.
Yep.
All right. Well, I promise we'll get back to the other questions.
Yeah, fine.
It's just one of those I've always wanted to know, and it just came to me. So, all right, we will get to your questions here coming up in just a few minutes. If you've got some, you can send it to ask@DeWittLaw.com. DeWittLaw.com. And also, if you need some legal advice, you can call the office 1-800-DeWitt Law. That's 1-800-DEWITT Law. And again, if you want to leave a voicemail, if that's easier for you, you can call and leave a voicemail with your question at 407-53 Moses. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards, here with Mo DeWitt of the DeWitt Law Firm. Getting your questions answered this morning and getting some advice, you can send them to ask@DeWittLaw.com. You can also call and leave a voicemail at 407-53 Moses. And if at any time during the week you need some legal advice, you can call the office right here at 1-800-DeWitt Law. That's DEWITT Law. Mo, we were just talking about car accidents and things like that. Is there ever a point in time to where, even though maybe you're not your fault, you're just a magnet for bad luck on the roads, to where that, even though none of them are your fault, where eventually your insurance could go up because of other people's bad driving?
Yeah. So in Florida, if you're not at fault for an accident, legally, the insurance company cannot raise your rates, even if you make a claim against your uninsured motorist coverage or your personal injury protection coverage, which, as we said on the show many times, make sure you have uninsured motorist coverage. It's literally the most important coverage you can have in the state of Florida, because so many people are out there driving without any coverage. Even if they're driving legally, which a lot of people are not, you can legally drive without any bodily injury coverage, which is the coverage that covers you if somebody hits you and hurts you. So you want to make sure you have uninsured motorist coverage.
Okay.
So legally in Florida, if you make a claim and you're not at fault, they cannot raise your rates. The only exception to that is if you have, I believe it's either 3 claims within 3 years or 3 claims within 5 years. I'll have to go back and look it up. But basically, if you're in a bunch of accidents, then at that point, they can raise your rates. Now, one thing I did have happen with a client recently was he was not, so you have to look at, okay, what's defined as at fault? It's basically usually being more than 50% at fault for an accident. So he was in an accident and he was not at fault, but for whatever reason, the insurance company reported him as at fault. And then they tried to raise his rates. And so he ended up switching insurance companies and got it straightened out. But, you want to make sure that they're reporting things properly on your insurance record. So if your rates go up, you want to ask them, hey, why did this go up? And if they say they were at fault for you were at fault for an accident, then you want to say, no, I wasn't. And hopefully you have a police report. Hopefully, maybe you have some dash cam video or something like that. But, it's kind of like your credit report, right? You want to make sure that there's nothing on there that's not accurate. So something to keep in mind. But yeah, unfortunately, even if you're if you just have bad luck, if you're out there driving with these crazy drivers on the road and you keep getting smashed into, at some point they can legally raise your rates. But as long as that doesn't happen, if it's a fairly infrequent occurrence, that's why you have insurance. You can legally make a claim, and it's actually illegal for them to raise your rates in the state of Florida. I should say though, they can legally remove some of the bundling stuff like that.
Or the safe driver and all that kind of stuff.
Yeah, so something like the quote unquote discounts that they give you.
Yeah,
they can remove those, but they can't legally raise your rate. So a little bit of what do you want to call that? Just not maybe the most ethical policy there, but they're legally allowed to do that.
So I guess if the worst case scenario, you didn't personally file a claim, if somebody else were to hit you 3 times, whatever, in that 3 or 5 year span, you could always shop around and find a new insurance company. And when they ask you, have you made a claim or anything like that? Technically, you haven't, because it's been the other people that have hit you. Is that correct?
Well, you're going to want to tell them anytime you filed a claim with your insurance company, whether it was your fault or not. Now, if you're in an accident, nobody files a claim, it's just a fender bender, then yeah, that wouldn't go against that rule because there was no claims made there.
Right.
But anytime you file a claim, you want to be very honest with that. And frankly, the insurance company has a database that's shared amongst all insurance companies. We can't see it, but they can see every claim you've basically ever made in your life against any insurance policy if they want
to. So even to another insurance company, because you're not getting yours involved, they'll still see that?
Oh, yeah, absolutely.
Oh, good to know.
I mean, we had a case recently where they asked the lady, hey, have you ever been in a car accident? And she said no. And then they said, well, you were in this car accident in 1992. And she goes, I completely forgot about that.
It's 20 plus years ago,
right?
30 years ago.
And it was a minor accident,
Right.
so she just didn't remember. She wasn't trying to be deceitful by any means. She just didn't remember. But yeah, they can go back. They have your complete insurance history. They can see everything there.
Interesting. All right, we got your questions coming up. I got a question about prenups coming up in just a minute. So if that's your question, hang tight. Or if you want to hear the answer, we've got that one coming up next. Also, if you still want to get your question in, whether it's this week, next week, ask@DeWittLaw.com, ask@DeWittLaw.com. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
Oh, hey there. I was just staring at this check that we just got for $20,000 for a guy who was hit by a car while riding on his one wheel. The initial offer in this case was just over $3,700. That's well over 6 times the initial offer. And that's why you call Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. Here with Mo DeWitt of the DeWitt Law Firm. Mo, what's the website? Where can people find out more information about you guys here?
So DeWittLaw.com, DeWittLaw.com. Check us out there anytime. You can always give us a call, 1-800, can't talk today, 1-800-DeWitt Law. That's 1-800-339-4885. If you want to schedule a consultation or reach the office, that's the way to get a hold of us. And there's people there 24 hours a day answering the phones, and they'll get a message to us if they need us or if you need us. But if you just have a legal question, if you want to participate in the show, have a question, a little question here or there, you can always email us, ask@DeWittLaw.com, or call the voicemail line for 407-536-6737.
All right, I just got in another email. Somebody else has a question. They're coming in. They're coming in left and right. So we give out the information and people have questions. So let's go ahead and go to this one right here. This one comes from Dawn. Dawn says, I want to know about Florida law regarding prenup agreements. Do both the future husband and wife need to have their own separate attorneys to make it legitimate and hold up in court in case something goes wrong, or can we use one attorney for everything?
So one attorney cannot represent both of you because there's a conflict of interest there. So whenever you're entering into a prenuptial agreement, if it's challenged down the road, which, as we've talked about before, as attorneys, we always think worst case scenario, what's going to happen here? If it's challenged down the road, what the court's going to look at is, was this contract, because a prenuptial agreement is just a contract, was it entered into freely and voluntarily with sufficient information to make an informed decision? So one attorney cannot represent both parties. That being said, one attorney can draft the prenuptial agreement on behalf of the husband or the wife, and then you have to give the other side the opportunity to seek legal advice. So this is where prenups get overturned a lot is, it's the night before the wedding. You've spent 30 grand on a wedding. All your friends and family are coming. You're basically pressured into signing it because you don't want to cancel the wedding.
Right.
So you have to, give ample opportunity to review that prenuptial agreement with a lawyer. Sometimes if there's a financial disparity between the parties, you have to give a budget for the other side and basically say, as part of this prenuptial agreement, I'm giving you $1,000 or $500 or whatever it is to go seek legal advice for this prenuptial agreement so that that person can't say, I didn't have the money to seek out a lawyer and get legal advice.
Right.
So there's all these different avenues that people have utilized to basically overturn prenups down the road. And that's now why we keep modifying the prenup every time a new case comes out to avoid those types of situations. So, you want to make sure they have the time and the opportunity to have it reviewed by an attorney. But at the end of the day, if the other side is just going to sign off on it, they don't have to seek an attorney. They don't have to get legal advice. They just have to have the opportunity to get legal advice. The other big thing with prenups is they have to be entered into with full information. So usually in our office, what we do is we have each side do a financial affidavit, basically saying, I'm swearing under oath that this is, my income, my expenses, and my assets and my liabilities, so that the other side can't later say, oh, I didn't know that you had, $500,000 in a bank account. If I knew that, I would have never signed this.
Right.
And those financial affidavits are then initialed by each party and attached actually to the prenuptial agreement. So there's never any dispute over, was this entered into with full information? Now, Obviously, somebody could lie on the financial affidavit. That's a different story. Don't do that because that will get your prenup overturned very quickly. But that's, again, one of the ways to try to avoid someone being able to challenge a prenuptial agreement down the road.
Do people really do that the night before the wedding? All of a sudden they bust it out and like, hey.
Numerous cases on it.
Really?
Numerous cases.
That's so wrong.
Well, and you kind of wonder too, okay, was the person who, decided to pull out the George Costanza.
Right.
Yeah. We need a prenuptial agreement and I'm really trying to get out of this wedding. Right. And the other says, yeah, sure, I'll sign that. No problem. So maybe there's a little bit of that going on there too. But yeah, I mean, it happens all the time. Or, maybe it's a last minute wedding. Who knows what the circumstances are, but yeah, it's happened definitely more than once. That's for sure.
Nothing like ruining the rehearsal dinner.
Oh yeah.
All right. This one comes from Justin. He says, hey Mo, I hear you probably hear this a lot, but when determining child support payment amounts, is it possible for the two sides to agree on a number that is fair and reasonable to pay, or does the amount have to be set by the Florida Child Support Calculator? Says the calculator came up with an amount that is not even close to reasonable for my income, and I'm able to work with my soon-to-be ex-wife. Just wanted to know if the court acknowledges things like this.
So we hear this a lot, honestly. If you're paying child support, a lot of times you think it's too much, and if you're receiving it, you think it's too little. At the end of the day, it is just a formula. And so the formula is based primarily on, the number of overnights you have, the incomes of each party, and who pays for health insurance, and if there's any daycare costs.
Okay.
That being said, technically you cannot waive child support, and you cannot just agree to some random amount. There's ways to deviate here and there if there's a legitimate deviation. But usually the court's not just going to let you agree to pay whatever you want.
Okay.
And I know it was a client whose parents did this actually, and the court made them pay child support. So dad would write mom a check for, I'm just making up the number, $300 each month. And then mom would just write the check back to dad because they didn't want to have child support, but they had to do it. It's a little silly, but that's what they did. That's what his parents did for years.
Little paper trail.
Yeah, because he didn't want to get in trouble with the court for not paying it. But here, I would first recommend make sure you're doing the calculation properly. If you haven't used the child support calculator before, you want to make sure you're putting the information in properly because, garbage in, garbage out. So one of the biggest factors is going to be, are you doing the overnights properly? And so in Florida, if you have less than, I think it's 73 overnights, less than 20% of the overnights, for purposes of child support, they're going to assume that the other party has the child 100% of the time, which is going to greatly increase your child support.
I got you. Okay.
Now, you also want to make sure you're putting the proper tax consequences on the income that you're putting in there, depending on how you're employed. If there is daycare costs, you want to put that in there as well, because that will be an offset. You want to make sure that you're including all the health insurance costs in there. So there are some tricks in there. And usually when I see someone who's saying, hey, this is crazy high, and I have equal time sharing, 50-50 time sharing, it's usually that they're not doing the formula properly.
Some sort of little mistake they made.
Yeah. Now, when you have multiple children and, there's a big income disparity, then child support can be rather high, especially if you don't have a lot of time sharing. So, yeah, I'm not saying that it's always too low or too high. I'm just saying a lot of times when I see someone and they're asking this question, essentially, it's that they didn't put the information into the calculator properly. So, it might be worth sitting down with a family law attorney and having a consultation, even if you don't need to, hire them for representation. Sit down with them, ask them to calculate child support for you. There used to be a great free app that was out there, but they've discontinued it. Unfortunately, I used to be able to tell people, hey, just go on this app, and it was pretty simple. It wasn't perfect, but it would give you a good estimation.
Right.
It's been discontinued, so I can't do that anymore. So you might have to sit down with a family law attorney and just have them calculate it for you, see what it comes out to, see if it's close to your number or if it's off. But yeah, usually that's going to be the issue, is just making sure that you're putting all the information into the calculator properly.
Right. And so, yeah, the courts are not going to let those two just come up with their own.
Yeah. So child support belongs to the child, so the parents cannot technically waive it.
I got you.
So that's the issue there. Now, like I said, sometimes there's some creative ways to deviate from it. If there's one party's paying a bunch of the child's expenses, sometimes the court will allow them to, in lieu of child support, pay X, Y, or Z expenses.
For like cheerleading or that type of thing? Or
sometimes that falls extracurricular. Usually it's more of if they go to private school or something like that. Again, that's a judge by judge situation, case by case situation. It really depends whether the judge will allow it or not. But if you're looking purely technically at Florida statute, the child support belongs to the child. It cannot technically be waived. You can ask for an upward departure, an upward deviation. If there are special expenses, you can ask for a downward deviation. For other reasons, if it's de minimis, sometimes if it's under $50, the court will just waive it because they say it's de minimis. So there are little tricks in here and there. But technically you cannot waive it because it's for the benefit of the child.
All right. Let's get on to our next question. This is from John. John says, here's what's happening. I bought a house with my ex 3 years ago in February. Shortly after we moved in, she decided we weren't working and she moved out. It's been 2 years since she moved out. I looked into refinancing her name off the mortgage, but it's not plausible for me to afford right now. Says she is not threatening to me to court or anything. I was just wondering what I should do or what could happen. Thanks for your advice.
So if you're both on the deed to the home, basically what she can do is she can file for a partition action, basically asking the court to force the sale of the home. Mm-hmm. Now, in this situation, you're probably best to try to refinance the house or remove her name from the mortgage, remove her name from the obligation if you can. If she files a partition action, really there's no defense to the partition action other than just dividing up how the proceeds are going to be split. Mm-hmm. If one party paid for all the asset or all the down payment and the mortgage payments and they can show all that, then you may be able to make an argument that you should receive all the proceeds or some of the proceeds or more of the proceeds, whatever it may be. But ultimately, she can still force the sale of the home. Now, you could, of course, buy her out of the house that way, but then you're going to have to basically refinance anyways and pay her a chunk. And in a partition action, the parties can ask for attorney's fees, too. There's an attorney's fees provision as part of a partition action. So, long story short, if you can avoid that and work something out with her, that's probably your best case scenario. But because you guys own the home together, typically you're going to own it as co-tenants. Basically, you each own a 50% interest in the home. The only option you really have is to buy her out or sell the home and divvy up the proceeds.
Okay. All right. Got another home question for you. This is another one of those that just came in. Said, got to decide what my next course of action is. Don't want to waste anybody's time. My wife's attorney is claiming that our home was purchased with money that was quote unquote gifted from her mother under an LLC. So this may be accurate from a previous home we lived in when we got married in 2016. My wife then sold that home purchased and then purchased the current home under the same LLC. But as of February of 2021, my name and my wife's name are the grantees on the deed, which she signed over as an officer of the LLC. Says the attorney claims that the gifted money used to purchase the original home transfers to the new home purchase while married, and that the gifted money continues to be a non-marital asset, and I can only negotiate regarding the current equity of the home. Says I had concerns regarding something he said. It appears that negotiating for my wife, maybe not so much for me.
So let's bring that back to the previous question about the prenup. Mm-hmm. One attorney cannot represent both parties. So he's absolutely right that he's negotiating for his wife. Okay, he represents her. He does not represent you. And so, anytime in any family law matter, especially a divorce, if one attorney is kind of acting that they represent both parties, they don't. Now, a mediator is different. A mediator is a third party neutral. They don't represent either of you. Right. But if somebody's coming to you and say, hey, I represent your wife, but I'm here to try to help you out, they don't. They can only legally and ethically represent one interest because there's a conflict of interest.
Yeah, absolutely.
Yeah, I mean, the advice that he gives her is beneficial to her. It's not going to be the same advice that the attorney would give to him. Mm-hmm. It would be, it doesn't work that way. So here, the biggest thing from his question that pops out at me is they added him to the deed of the home. And so usually when you add somebody to the deed of the home, it becomes commingled, which basically means whatever money was put into it or anything like that, there is an intent now that he owns 50% of that property. Okay. That's why he was added to that property. There's a few minor defenses to that I won't go into here that we've argued in some cases before that are very factually specific. But in 9 out of 10 cases, once you add someone's name to whether it's a bank account, a deed, any sort of asset where you're adding their name, it now becomes marital. And I've told this story before on the air where the guy got divorced from his wife. His wife took half the home. a few years later, they met at a bar, fell in love all over again. And he said, "Hey, honey, I love you so much. I'm going to add your name back to the deed of the home." And she took half the home again. So he paid her 75% of the value of the home over the course of the 2 divorces from the same person. So, it's the courts look at that as you intended to gift that person half of whatever that asset is. And so, another thing to be careful of is if you ever receive an inheritance, if you put that inheritance into a joint account or mix it with marital monies, there is an argument that it becomes commingled. It becomes all marital because the best description I've ever heard of commingling is you crack 2 eggs, you put them in a bowl, you stir them around. You can't tell one egg from the other now, right? So when you have money that you inherited, which is always non-marital. So I should have started with that is when you inherit money, even if you're married, that is one of the exceptions to a marital asset. So as long as you leave that separate, that is your personal money, it does not become marital. The second you start putting marital funds in there and then taking other funds out, now you can't tell what funds are what. As well as if you add the other party's name to that account, now it's considered to be a gift, that half of that money becomes theirs. So you want to be very careful with inheritances. And even if you have the best, strongest marriage, as every divorce client I've ever met does,
of course,
or did at one time, keep it separate. There's no reason to combine that money. Just keep it in a separate account. Keep it in your name only. If you need money from that account, then pull that money in, use it for whatever you need to use it for. But otherwise, keep it separate as much as possible.
That's great advice because I never, ever knew that. Never even thought of it. Just figured you just put it in the old bank account with you and your wife. So
yeah, I mean, the other thing I've seen happen before is they put the money into a separate account, but when they got it, they had it deposited into their joint checking account. And then they moved it into a separate account there.
Too late?
Well, that one, it's traceable enough and it was in the account for a short enough period of time where we can, again, make a very factually specific argument as to why it was not marital. There was no intent to gift it there. It was merely, passing through the account to get to its final destination. So there, it was only there for about a week. Basically, he didn't have the other account set up.
Gotcha.
So we could argue factually this was not intended to be a gift. But it still, of course, led to more litigation because the other side argued it was marital and we had to defend that. And ultimately, because it was put into a separate bank account in that person's name only without the spouse, they were good.
Good to know.
Yeah.
Some good advice right there. All right. We got more of your questions coming up, plus our Mo Pro tip of the week on the way. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
About a year ago, I was in a really bad accident. I got my hand caught in a saw and I lost my thumb. Luckily, the doctors were able to put everything back together. Originally, we reached out to other firms to take my case and nobody would help us. But when we called Mr. DeWitt and his team, they were there to help through the whole thing. I'm extremely happy with the result. Extremely happy with the result. It was an easy process. They made it as easy as possible and we got the best possible result. Injured on the go? Just call Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm. If you've got your question, ask@dewittlaw.com is where you want to send it. ask@dewittlaw.com. You can also call and leave a voicemail with your question at 407-53-MOSES. Mo, this question is what is your favorite professional or college football team? I mean, it is Sunday, so...
am I contractually obligated to say UCF since we're here?
I mean, I feel like you should since I'm a UCF grad. So
there we go.
That's a great answer. Great answer. All right, here's actually one of the real questions. I divorced my ex-wife in 2017, which was a simple divorce. During the court hearing, I told the judge I want nothing. Gave my ex-wife the house. The mortgage is in my ex-wife's name. I am not on the mortgage. However, I can see that I am 50-50 owner on the deed. Is there a way that I can give up my 50% ownership of the deed? I don't want anything to do with this house.
So nice and easy solution. You just do a quit claim deed where you convey your interest to your wife. Now, one thing you want to do is you want to, on that quit claim deed, have it recorded pursuant to the final judgment. And the reason you want to do this is normally when you record any sort of deed, they're going to charge you dock stamp taxes on that deed. And usually the dock stamp taxes are based on the value of the property. However, there's an exception to that with a divorce. When it's recorded pursuant to a divorce, all you typically pay is the filing fee, which I think is $10. So instead of paying thousands of dollars to record it, you'll pay $10. So
Nice.
make sure you do that. Now, to kind of elaborate on this question, usually when you own a piece of property with your spouse, you own that property as tenants by the entirety, basically meaning you're kind of joint tenants, but you're married, so you own it together. After a divorce is filed, or finalized rather, once there's a final judgment of divorce, even if you don't change the deed, that deed then automatically changes pursuant to law to be co-tenants, where each own 50% of the property. Now, of course, the final judgment may award the property to one party or another, and then the final judgment would control that. But the divorce itself breaks that tenants by the entirety to where you're now co-tenants. So in this case, if the final judgment doesn't say anything about who gets the property, but you want to give her the property, then you just sign the quitclaim deed, say it's pursuant to the divorce decree, which I'm assuming it is based on the question here. That saves you the dock stamp taxes, and then you can accomplish ultimately what you're trying to accomplish. But I'm guessing in this case, you probably went on the property appraiser website for that county. They haven't gotten a copy of the final judgment, and you haven't recorded the deed, so they're still listing it pursuant to the last deed that's in their records. So you just need to file a deed with them.
Update it, basically pay your $10 and
Yep, exactly.
cool. All right, let's get to our Mo Pro Tip of the week. What do you have for us?
Well, I'm going to use one that I like to talk about a lot because I really do think it's one of the most important and valuable things that you can do if you live in the state of Florida, because the state of Florida is the only state in the nation where we don't require bodily injury coverage. And you probably know where I'm going with this already.
Yep.
But bodily injury coverage is the coverage if someone hits you in their vehicle and it hurts you. That's the cover that covers the damages that they cause. So, in Florida, we're not required to have that. And we also have a lot of drivers who are on the road who just are illegally on the road without any insurance at all. And the only thing that can protect you from both of those is uninsured motorist coverage, which what that does is it basically steps into the shoes of the at-fault driver and provides coverage if somebody hits you and hurts you. And so I often hear people say, well, I don't want my rates to go up, as we talked about before. Legally, if you make a claim against your uninsured motorist coverage when you're not at fault, as long as you don't have numerous accidents within a several-year period, they cannot legally raise your rates. It is there to protect you. Other people say, well, I have health insurance. What do I need, uninsured motorist coverage for? Well, if you're out of work for several weeks, months, sometimes even years, you're going to want to have uninsured motorist coverage. You may also have deductibles or need therapy that's not covered by your health insurance.
Right. Yeah.
Typically you have that annual deductible that you have to meet that could be out of pocket depending on your policy. Time you have to take off of work to go, to and from doctor's appointments. All that kind of stuff is not covered by your health insurance, where you're going to really want uninsured motorist coverage. It's actually, speaking to a client this week, and unfortunately we had to turn down his case because there was no coverage. He didn't have insurance cover or uninsured motorist coverage, and the person who hit him didn't have any coverage. And I had a very frank conversation with him. And he goes, before I even started, he goes, I already know. And I already switched my insurance policy, and I added uninsured motorist coverage because, before I thought, what do I need this for? Now I realize it. It's one of those things. Once you've been in an accident and you've been there, people realize why they need it. Unfortunately, we kind of live in a society where people say, that's just, I'm not a litigious person. I'm not going to file an insurance claim. But when you're really hurt and you need it, you want to make sure it's there.
Right.
And frankly, it's not that expensive to add either.
No, I took your advice. I mean, I've heard you say this before, and I'm like, okay, I'm taking them seriously. And I added it onto and I was pleasantly surprised by how inexpensive it was.
It's just one of those things you don't really know about or think about. If you're like me,
you need it.
Right. Exactly. You call your insurance broker saying, give me some coverage. What's the cheapest you got? I don't want to pay a bunch of money. You sign the forms. Nobody's reading that electronic contract. We all know how it works. And, you don't know what coverage you have. So you really want to look at it and make sure you have the right coverage for yourself.
Call and ask your insurance company today, tomorrow. Ask them if you've got it. It's the Mo Pro Tip of the Week. All right, we'll be back next week, same time right here. It's the DeWitt Law Review on 107.3 FM and AM 580. Again, send those questions to ask@dewittlaw.com, or you can also call the office for legal advice anytime at 1-800-DeWitt-LAW. It's the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
Someone ran a stop sign about 50 miles an hour and hit my truck basically head on, and it caused a lot of damage to the vehicle, but also hurt me as well. The insurance company reached out like, hey, we'll make this all go away if you just, sign this and take this money. And even though that was my first accident, I knew that that wasn't the way it should have went. And that's when I decided to call Mo.
So after the accident, the insurance company approached Mark and tried to give him $1,000 to waive all rights to bring a claim. Fortunately, he was suspicious and knew better.
So it was no, if you have a question, just call me at my office or email me here. And I really enjoyed that.
Ultimately, in this case, we were able to recover $110,000 from Mark's injuries.
He's funny, he's approachable, but he also knows what he's doing. And if I knew anyone who's injured and needed a lawyer, I would definitely recommend DeWitt Law Firm. If you're injured on the go, just call Mo.
Mark's a great guy, and I'm so happy that we were able to help him with his accident case.